my God. It's, so I wanted to, good morning, everybody. I was just talking into a muted mic. That happens a lot. But, I'm just saying that, we're going to finish off Antonin Scalia's confirmation hearing, his testimony, today. And then later today, we'll be doing Anita Hill, which isn't something I relish doing, but it's something that I feel like we kind of have to do. It's the most watched, confirmation hearing, at least it's of the entire stretch of Clarence Thomas's confirmation hearings. Good morning, Alex. Good morning, Alexandra. How's it going? I haven't finished my first cup of coffee, and I'm a little nervous because we're on the, that was my last espresso pod.
Massive change to go back on.
And similarly with the cruel and unusual punishment clause of the 8th Amendment incorporated by the due process clause of the 14th Amendment?
Same answer, sir.
Would you say that those would come into the categories of pillars of constitutional law?
Marbury versus Madison is a pillar. If that's a pillar, I don't know what. I would just say it's a very accepted and settled part of our current system, and it would be an enormous change to go back.
Thank you, Judge Scalia. Senator Metzenbaum.
Mr. Chairman.
Senator Simon.
Maybe Senator Metzenbaum.
Senator Metzenbaum has not had a round yet.
Pardon?
Senator Metzenbaum has not had his first round.
I apologize. I thought he had his question. Sorry.
Marbury versus Madison is a pillar. If that's a pillar, I don't know what. I would just say it's a very accepted and settled part of our current system, and it would be an enormous change to go back.
Thank you, Judge Scalia. Senator Metzenbaum.
Mr. Chairman.
Senator.
He had his question. Sorry.
Judge Scalia, in an article, I'd say parenthetically, you've been very patient. It must be a long day, and you must be a bit weary, and your family must be wearier. But I'm glad the younger portions went home. In an article entitled "The Judges Are Coming," you made this statement. It would seem to be a contradiction in terms to suggest that a state practice engaged in and widely regarded as legitimate from the early days of the Republic down to the present time is unconstitutional. I do not care how analytically consistent with analogous precedents such a holding might be, nor how socially desirable in the judge's view. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong. The problem I have with that statement is that the Supreme Court throughout our history has had the responsibility to declare that certain widely accepted practices violate the Constitution. For example, deciding that segregated schools were unconstitutional and that legislative districts had to be apportioned fairly. Are you saying that as a Supreme Court justice, you would oppose decisions which prohibited widely accepted practices? Or stated another way, does that mean that if a Gallup poll says 80% of the people have a particular point of view, then court decisions to the contrary, in your opinion, those decisions are quite simply wrong?
Can I talk about what I meant when I wrote that article instead of putting it in the context of what I would do?
No, I'm asking that.
Yes,
I'm not asking what you would do.
Right. The point I was trying to make, Senator, was simply this: there is an ongoing debate. It's always been ongoing, but it's just more publicly known now about strict constructionism versus a more evolutionary theory of the Constitution. And I am speaking particularly about decisions of the court that give content to provisions of the Constitution that are not sufficiently explicit to strike down particular practices. If a practice that constitutes plainly racial discrimination existed in all the states it would make no difference whether it existed from the beginning of the 14th Amendment down to the present. If it's facially contrary to the language, obviously there's no problem. And that's not the situation I was referring to. I was referring to the situation where a court is giving content to, in particular, the due process clause of the 14th Amendment, what particular substantive protections that might incorporate. And what I felt, and it was the point of that article, was that the judges have authority to give such content, no doubt, but I do not know how a judge intuits that a particular practice is contrary to our most fundamental beliefs, to the most fundamental beliefs of our society, when it is one that was in existence when the constitutional provision in question was adopted and is still in existence. Now, when I say a practice is in existence, I'm not referring to a Gallup poll. I'm referring to the understandings of the people reflected in the legislation that their representatives have adopted. I would find it very difficult, I was saying in that article, to strike down a provision on the basis of substantive due process in particular, where it's a provision that state legislatures generally adopted at the time the 14th Amendment was passed and continue to generally adopt. When one leaves that point of departure, you're left to the individual preferences of the judges, and I am not comfortable with imposing my moral views on the society. I need something to look to, and what I look to is the understanding of the people. The strict constructionist would say use only the understanding at the time of the 14th Amendment. The evolutionist would say no, the understanding today as well. Whichever of those two you use, and as I said in some earlier questioning, I'm a little wishy-washy on that point, but whichever of the two you use, it seems to me that either one or the other has to reflect the new right that you found. If it was neither there when the 14th Amendment was adopted nor is there today, then it seems to me, I was saying in that article, I'm making it up.
Well, it seems that you're equivalent of saying the Constitution means what the majority says it means. I have difficulty with this whole majority approach. And your language is very clear. If it contradicts a long and continuing understanding of the society, as many of the Supreme Court's recent constitutional decisions referred to earlier in fact do, it is quite simply wrong.
Well,
That's a very bold statement. Maybe bold is even a mild word.
well, maybe I shouldn't take it on frontally, but let me do it. I would even. It is true in a way, it seems to me, that a Constitution has to have ultimately majoritarian underpinnings. To be sure, a Constitution is a document that protects against future democratic excesses, but when it's adopted, it is adopted by democratic process. That is what legitimates it. And the point I was making in that article is if the majority that adopted it did not believe this unspecified right, which is not reflected clearly in the language, if their laws at the time do not reflect that right existed, nor do the laws at the present date reflect that the society believes that right exists, I worry about my deciding that it exists. I worry that I am not reflecting the most fundamental, deeply felt beliefs of our society, which is what a Constitution means, but rather I'm reflecting the most deeply felt beliefs of Scalia, which is not what I want to impose
Judge,
on the society.
The real problem I have with your article and your own statements today relates to the fact, and I'm sure you remember it, that when the Kefauver Committee was active, I wasn't here in this body, but I remember there was a great hue and cry to repeal the Fifth Amendment. Anybody taking the Fifth was per se practically bad person, we ought to repeal the amendment, that'll solve it so they can't take the fifth. And then I have a recollection of somebody's poll, and I don't know whose, whether it was Gallup or somebody else, checking with people as to their views on each of the separate constitutional amendments to the Bill of Rights. And overwhelmingly, American people indicated they don't support that concept. Now, I sit here concerned, is this new Justice of the Supreme Court going to start to find ways to change that Bill of Rights? Because it is a fact. It is tougher. It is one of the toughest things that some of us have, and that is to stand up for an unpopular point of view on the basis that that's a person's constitutional right. It's sometimes, I guess I remember one case, the case up there in Illinois, where the Nazis were picketing, or they were marching, and the Jewish community came out en masse to try to stop them from doing it. And I remember the American Civil Liberties Union got into great trouble because
Skokie, as I recall.
Pardon?
Skokie.
Skokie, that's right. And in that case, the American Civil Liberties Union lost a lot of its members, but they stood up for what they thought were their constitutional rights, even though they'd be unpopular. I'm worried about you're going on the court and reacting. What's that? Let me just. 15-minute roll call. I guess they reform Republican senators as well as Democrats. I think I may have cut you off. Had you finished?
No, you just made a statement that I don't disagree with your concern. All I can say to it is that the views I expressed certainly do not reflect the notion that I will be swayed by Gallup polls or by current public opinion. To the contrary, if there is an established constitutional right that has been set forth in the Constitution, and that or even if not set forth very explicitly, is clearly established by the practices of the society, I would assuredly not allow the mere fact that the current society, inflamed by one passion, prejudice, or another, wants to stomp it out. I would not allow that to affect my judgment. Quite to the contrary.
Let me ask you a little bit.
I don't mind taking unpopular positions, Senator.
Let me ask you a personal matter about your membership in the Cosmos Club. I think you were a member.
Yes, sir.
You were a member from 1971 to December 85. I think the Cosmos Club excludes women from its membership. And I think the ABA's position is that the membership of a judge in an organization which practices discrimination may give rise to perceptions by minorities, women, and others that a judge is not impartial towards minority groups. And then the ABA Standing Committee on Ethics and Professional Responsibilities has been considering the impact on the judiciary of judges who belong to discriminatory clubs. And the Judicial Conference in 1981 adopted a resolution that it is inappropriate for a judge to hold membership in any organization that practices invidious discrimination. And then in '83, the ABA Ethics Committee submitted to the House of Delegates proposed amendments on the membership of judges in private discriminatory clubs. More than half the population is female. And the women of the country have some concern, rightful concern, about a jurist who undoubtedly knew about some of these provisions of the ABA and the Judicial Conference. Do you want to comment on that?
Well, I certainly agree, Senator, that a judge shouldn't be a member of a club that practices invidious discrimination. I think the issue is whether that was invidious discrimination or not. I certainly would not belong to a club that practiced racial discrimination, because I don't think there's any basis for socialization on the basis of race, that there's any difference in company on the basis of the color of a person's skin or ethnic background.
Did you know the Cosmos Club discriminated against women? What, didn't have any women?
I knew that it was a men's club, and what I was going to go on to say is that I don't consider that an invidious discrimination. I think there are a lot of other people who likewise do not consider it invidious discrimination. I realize there are those that disagree, that do not like organizations like the Knights of Columbus, or for that matter the Boy Scouts, and think that that should not be an all-male organization. I happened not to have felt that way, and thus was a member of the Cosmos Club. When I first joined it, Senator, was when I first came up to Washington to work in the executive branch. I lived in the club for about 6 months while my family was still in Charlottesville. One of the facilities of living there was that it was a men's club. Now, I understand there are people who feel differently about it. I am sensitive to their views. Towards the end of the period that I was membership of the club, that I was a member in the club, I was especially uncomfortable, because I know that some of the judges on my court took the opposite view of whether there should be clubs of that sort. I happen to disagree. I'm no longer a member. That's all I can say.
I note you used a rather interesting story to illustrate one of your objections of affirmative action, and that's the story of Tonto and the Lone Ranger, and in it I think you have tell the story with the Indian dialect of English. I won't read the whole story, but it's a cute story, but the English dialect of the Indian I'm not quite so sure about. Everyone who knows you says that you are quite adept with the English language. The fact that you have exceptional verbal talent. How do you think the Indians of this country might feel about your reciting that story with some of the quotes?
Would you read the quote where I use
yes,
the?
Yes. When John Minor Wisdom speaks of restorative justice, I'm reminded of the story about the Lone Ranger and his faithful Indian companion Tonto. If you recall the famous radio serial, you know that Tonto never said much, but what he did say was, disguised beneath a Hollywood Indian dialect, wisdom of an absolutely Solomonic caliber. On one occasion, it seems that the Lone Ranger was galloping along with Tonto heading eastward when they saw coming towards him a large band of Mohawk Indians in full war dress. The Lone Ranger reins in his horse, turns to Tonto and asks, "Tonto, what should we do?" Tonto says, "Ugh, ride 'em west." So when they wheel around and gallop off to the west, suddenly they encounter a large band of Sioux heading straight toward them. The Lone Ranger asks Tonto, "What should we do?" Tonto says, "Ugh, ride 'em north." So they turn around and ride north, and sure enough, there's a whole tribe of Iroquois headed straight toward them. The ranger says, "Tonto, what should we do?" Tonto says, "Ugh, ride 'em south," which they do until they see a warpath of Apaches coming right for them. The Lone Ranger asks Tonto, "What should we do?" Tonto says, "Ugh, what do you mean, we, white man?" And it's a rather cute story, but I think the use by you of a sort of a Indian dialect, I wonder if the Indians would feel offended by it.
I'm fully aware of that sensitivity, Senator, which is why when I began the story, I made it clear that Tonto's wisdom was always Solomonic, but it was disguised between what I referred to there as a Hollywood Indian dialect. That is a disparaging term. I'm fully aware that Indians don't talk that way. It's how Hollywood portrayed them. I thought I made it very clear in what I wrote, that Indians don't talk that way, but that's the way Hollywood wrongfully portrays them. Now, if that is not enough of a disclaimer and the story has to be stricken from everyone's repertoire, I think that would be a great loss. And it doesn't work in non-Hollywood Indian. It really doesn't.
There's now a pending request for certain memoranda that we have worked out in connection with Justice Rehnquist. He waived any objection to our having that information. Do you have any objection to our obtaining information from the Justice Department concerning your efforts while you were there?
Personally, Senator, I have no personal objection to it. There's nothing I did at the Justice Department that was other than honorable. I'd be less than honest if I didn't say that having worked in the Office of Legal Counsel and defended its prerogatives for 3.5 years or so, I'm concerned about the institution, about the effect that such probing, or more specifically, the awareness of the fact that whatever the head of the Office of Legal Counsel writes will henceforth, should he ever be subjected to questioning in connection with a confirmation, which is very likely because most heads of the Office of Legal Counsel, or many of them at least, go on to later government positions. I think it would be harmful to the office if it is known that everything he puts down on paper by way of advice to the Attorney General or to the agencies will be made public. I fear that it may make his advice less frank, less forthright than it otherwise would be. That's purely an institutional objection. It's up to the President to defend that institution. Personally, I'm not ashamed of anything I did while I was there.
And you have no personal objection?
I have no personal objection, Senator.
I have no further questions.
Thank you. Take recess, and the first, after the recess, James Sons from Illinois.
I thank you, Mr. Chairman.
We'll take a recess now and go and vote.
Stands for. Let me first throw you a softball question. You will be one of the leaders of the law in this nation. You have been a law professor at Stanford and University of Chicago, University of Virginia, I believe. We, in 1970, had 270,000 lawyers. We now have 640,000, graduating about 39,000 a year. There are those who believe the numbers are so high that it can present problems in our society. Do you have any reflections on this? And if so, if there is a problem, what we do about it?
I share the perception that there is a problem, Senator. I'm not entirely sure what to do about it. To some extent, the problem feeds on itself, of course. There's the story of the fellow sitting in a train and the gentleman next to him asking him what he does, and he says, "I'm a lawyer," and the fellow says, "Gee, what do you know that? We used to have a lawyer in my hometown. Poor devil, he could hardly make a living. Then another lawyer moved in. Now they're both doing fine." To some extent, the very increase in the number of lawyers creates yet greater litigiousness. I don't know whether it's, it does seem to be a trend that is beginning to slow down a little bit. The answers that are being sought are alternative dispute resolution mechanisms other than the courts. And my understanding is that there is some success with those mechanisms. Unfortunately, the resort to those mechanisms is in itself something of an admission of failure. People want to resort to them because the courts are too crowded, it takes too long to get justice there, and it's too expensive, which is a sad commentary. I'm afraid I just don't have an answer. I share your perception of the problem.
It was not a question you expected to be asked during this hearing. I have an idea.
I didn't.
Let me read from a staff memorandum along with your opinion. It draws this conclusion. It says, "From these and the other cases included in this book, it's easy to see where Scalia's sympathies lie. He will interpret civil rights statutes narrowly. In cases of race discrimination, a plaintiff will have a very difficult time proving his case because of the high standards Scalia imposes on race cases. The same will be true with gender discrimination. To be sure, the court will have an ardent enemy of affirmative action in Scalia, and in future cases, he can be expected to leave his mark. In his article, quoting from an article of Washington University Law Quarterly, you say, Justice Powell's opinion on affirmative action, which we must work with as the law of the land, strikes me as an excellent compromise between two committees of the American Bar Association on some insignificant legislative proposal. But it is thoroughly unconvincing as an honest, hard-minded, reasoned analysis of an important provision of the Constitution. Do you have any comments on my staff's conclusion looking at that area of your decisions, and any reflections on your Washington University article?
Well, we discussed that article a little earlier, and as I said there, it was addressing mainly the policy of affirmative action, not its constitutionality, whether it was desirable. That is, of course, a disagreement concerning the means to the end. I hope there's no doubt about my commitment to, or there should be no doubt about my commitment to a society without discrimination. If the notion there is that I'm hostile to laws that seek to eliminate that, that's simply not true. I'm in a way having any animosity towards racial minorities, in my case, would be a form of self-hate. I'm a member of a racial minority myself. Suffered, I expect, some minor discrimination in my years, nothing compared to what other racial groups have suffered, but it doesn't take a whole lot to make you know that it's bad stuff. My wife's mother remembers the days, she's a Fitzgerald from Boston. I wish Senator Kennedy were here to know that. But she remembers the days when there were signs in Boston that said, "No Irish need apply." I find all of that terribly offensive. I'm a product of the melting pot in New York, grew up with people of all religious and ethnic backgrounds. When I lived in your state, Senator, I didn't live in a monochrome suburb, but I lived in Hyde Park, and my kids went to school, a school that was at least 40%, maybe more than that, black, not white. My kids socialized with and dated people of all races. I have absolutely no racial prejudices, and am, I think, probably at least as antagonistic as the average American, and probably much more so towards racial discrimination. Beyond that, I can just say that I disagreed with affirmative action in that article as the way to eliminate it, because of side effects that I saw that could be worse than what was than what the particular affirmative action program would eliminate. In any case, those policy views will not inform my decisions on the Supreme Court, as I do not think they have informed my opinions on the Court of Appeals. I think it would be a different matter if those opinions showed any racial hostility or hostility towards the laws, and I don't think they do.
Let me phrase the question a little differently. Let's use an imaginary scene at the White House that might have taken place. The President asked the Attorney General, "Get me the 6 best names you can get in the nation." And he comes up with 6 names. One is named Jones, one Smith, and he looks through, and one is named Scalia. And the President says, it'd be a good thing to have an Italian American on the Supreme Court. 6 outstanding nominees, and it is not difficult in this great land to find 6 outstanding nominees. is there anything fundamentally wrong with the president making a decision on that kind of a basis in part, assuming you have 6 quality people there?
Fundamentally wrong you mean on illegal or morally wrong?
Well, from the viewpoint of the theory of government.
No, I think that it's a good thing. Certainly in my own hiring practices, I've tried to have a mix of people among my law clerks and elsewhere. No, I can't say that that's
okay.
That's
and so if Congress, through the if we decide that affirmative action, if we see a plant where there are 2,000 whites and no blacks, we say, as you award contracts in the defense area, let's try and encourage employers to follow practices that give opportunities for people. We're not saying you should hire people who are not qualified, but let's have a society where there are opportunities for everyone. If Congress passes laws requiring that, and I don't want to get into, we're getting close to territory that you may feel uncomfortable responding on, but just in the abstract, do you find that offensive from a legal point of view?
I don't want to. In the days when I wrote that article, I actually gave that speech, which became an article in the Washington University Law Review. I had policy views. I've tried not to have them, not have any public ones anyway, since I've been a judge. So I'd like not to comment on it as a policy matter. I just want to note that there is a difference between the first hypothetical you gave me and that. That is, and the difference is this: it's the president saying, it seems to me it'd be good to hire Puerto Rican or whatever, as his own voluntary decision, and on the other hand, saying the president or anybody must hire an Italian or a Puerto Rican or a certain percentage of them. The difference is that when you adopt the latter situation, you are automatically excluding some people from consideration. Now that makes a difference just as a policy matter. So it's a slightly different question. I guess that what my Washington University piece would say is that in the days when I had policy views, I didn't think it was a good idea. That has nothing to do with whether I would enforce it vigorously if it's passed by Congress.
I guess my experience is through life, and maybe yours too, that if you have policy views, inevitably they creep up or creep out or appear when you are on the Supreme Court or in any other position. But I guess what you're telling me is that is a policy matter for us to decide here in Congress, and you do not, and again in the abstract, you don't see a constitutional prohibition to Congress moving ahead.
Well, I guess we can get into the question whether the latter is a pillar or not, but I would like not to express a view on constitutionality of the matter, but certainly the policy of the matter is entirely Congress's. I am certainly in sympathy with the objective of Congress. Whether I am in sympathy with the particular means Congress has pursued to that objective, I assure you, will have nothing to do with my decision in the case. I understand that it's hard, but it's a discipline that a good judge has, and I think it's one that I have.
Let me shift to another area. After looking at your decisions in the First Amendment area, this conclusion is drawn here. In all 3 of the important libel cases that have come before him, Judge Scalia has ruled against the press. I received a memo from my colleague, Senator Dodd of Connecticut, expressing some concerns in this area. And now, you have in part answered this question to one of my colleagues, but any kind of generalities you would like to make in response to this characterization of your stands?
I'd be happy to talk about the three cases, if you'd like. What three was it referring to?
They are referring to the one was the mobile Pablo Rios, if I'm pronouncing it correctly.
Well, that was not. That is the one case one of very few cases I can't talk about because it's still before our court on petition for rehearing, but I can at least note that it was not my opinion. It was the opinion of Judge McKinnon in which I joined. The holding of the case was on a factual matter. I think I'd better not try to defend the holding at all, except to note that the opinion was not mine. It was an opinion in which I joined.
But that characterization of your decisions, you believe, is not an accurate characterization.
I think sometimes you win, sometimes you lose. The fact that I've ruled or joined an opinion against the press doesn't prove anything. What are the other opinions, Senator? I think I can probably guess them.
The other one that's quoted here quite a bit is the Ullman versus...
Evans and Novak versus Ullman. Senator Hatch said a few words about that case earlier. It really is, as I think he pointed out, a sort of damned if you do, damned if you don't situation. I could have been criticized as being against Marxists had I come out the other way. It was a suit by a Marxist against a conservative columnist. The fact is that my dissent in that case, it's a dissent that they're referring to, was joined in by, if I recollect correctly, Chief Judge Robinson. The position that I took was joined in by Judge Robinson, Judge Wright, Judge Edwards, and Judge Wall. My opinion itself was joined in by Judge Edwards and Judge Wall. I don't think that that's any indication of a bias against the First Amendment, unless all of those judges are deemed to have the same bias, which I would doubt. The specific issue in the case was whether it was a very narrow issue. We were all in agreement on the basic principles of First Amendment law, that it was libelous if it was not an opinion, it was not libelous if it was an opinion. And the issue before the court was whether the statement that this Marxist professor, who was up for appointment as chairman of the Department of Political Science at University of Maryland, the statement that he had no status in his profession was not taken seriously by his colleagues, something to that effect, whether that was libelous. I thought that was not a statement of opinion, but a statement of fact, that he was not highly regarded by his colleagues. And in fact, in traditional libel law, the classic libel is to say that you are not regarded as a competent by your professional associates. I just don't believe that there's anything in there that's antagonistic to the First Amendment. I think the opinion that I wrote, which largely responded to Judge Bork's concurrence, had a statement which was quoted by a columnist to the effect that public figures getting a good amount of bumping from the press was fulsomely assured by New York Times versus Sullivan. It somehow came out in the press as though I was saying that the freedom of the press was fulsomely assured by New York Times versus Sullivan. I wasn't saying that at all. I was saying the fact that public figures will get a good amount of bumping was fulsomely assured, by which I mean assured not only sufficiently but more than sufficiently. I don't think that there's anything in that statement that demonstrates an antagonism towards the First Amendment. And the last case, Senator, was what? I'd welcome the opportunity to...
But I think you adequately covered it here. Let me shift to another area. you testified in 1981 on the tuition tax credit case, and you said in testimony, Senator Moynihan was taking the testimony, the court's decisions in this field set forth neither a settled nor a consistent nor even a rational line of authority that you could rely on even if you wanted to. You were not aware you were going to be a nominee for the Supreme Court when you said that. Do you have any general, well, the whole church-state issue, any reflections on that?
I suppose doesn't give any indication how I'm going to vote on any particular case. To say that I don't think that statement is would be much altered today, and I doubt whether there are very many people who would disagree with it, with the possible exception of, well, even the rational. The decisions are very difficult to reconcile with one another. The decisions that are on the books, the court, the rationale that's adopted in one case does not fit entirely well with the cases that have been decided in the past. I think that's common ground among people who discuss the Establishment Clause cases. Whether the cases are thought of as being right or wrong, I think there is general agreement that it's one of the messiest areas of constitutional jurisprudence.
Well, assuming that, but do you have, are basic traditions pretty sound in this area, in the whole church-state area?
Basic traditions?
Yes.
I'm not sure what you mean by basic tradition, Senator.
Well, the constitutional principles as they have emerged over the past 2 centuries.
Well, I think what's sound is that what's accepted. The problem in the area, Senator, is a problem that largely arises because of a natural conflict between the Establishment Clause and the Freedom of Religion Clause. Both of those interests are very important. People ought to be able to practice their religion freely, and yet the government cannot establish religion. So you get cases like the case of the Jehovah's Witness, who wants to, being a Sabbatarian, wants to have Saturday off instead of Sunday, and wants to draw unemployment compensation when she's been offered a job that requires work on Saturday and turned it down. And the way the court resolved the case was to say it violated the Freedom of Religion Clause for a state not to allow her to draw unemployment compensation simply because she refused to accept a job that would require her to work on Saturday. Well, yes, that does protect freedom of religion, but on the other hand, doesn't that somehow amount to an establishment of religion, to have the state make a special rule to accommodate the religious belief of this Sabbatarian? That's the problem that runs throughout these cases, and that's the reason they are very hard to figure. On some occasions, the court seems to be giving more weight to the freedom of religion section of the First Amendment. On other occasions, it seems to be giving more weight to the Establishment Clause section. If I had to pick an area that, in the whole area of constitutional law, that is in an unsettled state, I think that's the one, and I think many commentators would agree.
I see my time is up, Mr. Chairman. Thank you.
Senator Illinois from Illinois is correct, and the second round will involve, according to previous announcement of Senator Thurmond, 10 minutes each, and the senator from Delaware is next.
I'm call home, Justice Scalia. That's the call. I'm sorry. I thought we were going to yield to my colleague. I appreciate that. I'll yield to my colleague from Alabama, and then maybe I could ask my question.
The senior senator from Alabama.
Thank you.
You've been previously asked about the Inner Circuit Tribunal. I have a question phrased as to whether or not the appointing power ought to be the Chief Justice or the President. under the proposed legislation, it's temporary court of existing officers of the United States who have already been confirmed under the Constitution. The selection of those judges has been debated. There seems to be two alternatives, one being it's be three alternatives, one being the Chief Justice appointing them, the others being the circuit themselves selecting their judge, and the third being the Supreme Court instead of the Chief Justice, all 9 members of the Supreme Court doing the selecting. Do you have any opinion on which you consider the better method of those three?
It sounds like the least of the evils offered, Senator, doesn't it? There are problems with all of them. It's very hard to envision.
Excuse me, Judge Scalia, if you could pull your microphone a little closer.
It's very hard to envision a court getting together for such a purpose to select one of its number to be the designee, or for the Supreme Court to select particular individual judges. It amounts to a kind of designation of ability and of primacy that I certainly wouldn't want to do it as a member of a court of appeals. I wouldn't particularly want to do it as a member of the Supreme Court either. Your judgment on that is as good as mine, Senator. I'd guess that having the Chief Justice do it is the least evil, but there are problems with that too. It doesn't give you the spectrum of opinion that having a body of people do it would.
All right, so...
Some questions don't have any good answers, Senator.
Well, sometimes can't get people to state a position. But let me ask you another matter. We've got an issue before Congress now on the impeachment of a federal judge. House's representatives has, in effect, brought articles of impeachment, which are in effect are an indictment. The Senate is supposed to sit as a trial judge. For the judiciary, this appears to be a very cumbersome process. Some of the states have had other procedures for removal of judges, and I'm not trying to prejudge or do anything pertaining to the one before us, but I just wondered if you have any thoughts on any innovations or improvements that might occur pertaining to problems that could arise with judges in the federal branch.
Giving this answer now that I'm a judge does make it sound as though it's self-pleading, but I had the same view before I became a judge. It is a cumbersome process. I think it should be a cumbersome process. I think it's the major protection for the independence of the judiciary. The bases for impeachment are somewhat vague, and the bases that past Congresses have sought to use in most prominent cases are pretty vague. It seems to me that it is an important protection to the independence of a judge to be able to decide cases as he sees them, that removing them is a lot of trouble.
Well, some of the states have had various methods. Some have had the equivalent of the House action taken through a Judiciary Inquiry Commission, and then have a court of the judiciary. which is largely composed of judges and maybe also some lawyers. Others have had commissions which deal with the disciplinary and removal matter. You don't have any feelings about those, or you think the impeachment is more of a protection of independence than those methods?
I think much more so, Senator, and it's not as though the framers didn't know that they were establishing something that was very cumbersome and very difficult. They were out of step with many of the colonies at the time in what they provided for the judiciary. And one of the major debates at the convention was the provision on the judiciary, giving them life tenure, for example. Our federal judiciary is out of step with the states in many other respects. Many states have mandatory retirement age, as you know. Many states still, I believe, have election of judges. And all of those things were considered and rejected in favor of an extraordinarily strong, extraordinarily more so than most of the colonies then and more so than most of the states now, an extraordinarily strong and independent federal judiciary. I think it was a conscious decision by the framers, and I happen to think it was a good one. I understand that it's, especially at a time when the Congress has plenty else to do, to have to sit in a trial of a judge is cumbersome.
I believe that's all the questions I have at this time, Mr. Chairman.
Senator from Delaware.
Thank you. You've had a long day, Mr. Justice, but from the time I've been here, it seems like you've had a pretty good day. And let me at least close out my questioning by asking for a couple clarifications and also to go into a little bit the privacy questions, Ninth Amendment. I understand in response to a question from Senator Metzenbaum, you indicated that you would not belong to a club that discriminated based on race, but you would not feel bound not to belong to a club that discriminated based on sex. Is that correct?
No, that isn't quite what I said, Senator. I said that I regarded the two as quite different, and that I would think that a club that discriminates on the basis of race or on the basis of religion would be invidious discrimination. I think the jury's out on whether it's invidious discrimination to have a men's club. That's what I said. I didn't say that I...
Try to hear the last part. The jury is out.
I think that there's room for disagreement on whether a social club that's a men's club or a woman's club is invidious to the other sex.
Could it be invidious if, in fact, the effect of keeping women out was to have a detrimental impact upon their ability to do business, or if they were business women, or participate in sport if they're sports women? Or
I can see that, Senator. Yes.
Would you? Where do you put the classification? I mean, in what context would you place those clubs which would discriminate based upon nationality?
Well, there's sort of a affirmative and negative discrimination, I suppose. There certainly. I've been a member of Italian American clubs that members share a common heritage. The exclusion of others is not an invidious exclusion at all. And
if in fact,
likewise, religious clubs. I mean, they're Knights of Columbus and whatnot. They exclude people of other religions, not invidiously, but just because they get together to celebrate what they have in common. I think that's the key to it, whether the exclusion is an invidious one or not.
If in fact there were a club or an organization that included not one group of people who shared anything in common other than the fact they didn't like the Irish or the Italians.
Yeah, I think that'd be invidious.
You've been questioned on this already, but in your, get to make sure I have the right title of the article, referred to as the Panhandle magazine article.
Yes, sir.
I understand that one of my colleagues quoted you, the provision that said, "I do not care how analytically consistent with analogous precedent such a holding might be, nor how socially desirable the judge's view, nor how socially desirable in the judge's view, if it contradicts a long and continued understanding of the society, as many of the Supreme Court recent constitutional decisions referred to earlier in fact do. It is quite simply wrong. There will be no relief from the most far-reaching intrusions of the modern judiciary until the Supreme Court returns to this essentially common law approach to constitutional interpretation." Now, as I understand it, if in fact it were a long-established societal view, it would... Why don't you explain it to me?
Let me try, Senator. I am deeply mistrustful of my ability, without any guidance other than my own intuition, to say what are the deepest and most profound beliefs of our society. And that's what it means to say that something is constitutionally required. It is in accordance with the deepest and most profound beliefs of our society. I find it difficult to come to the conclusion that something qualifies for that description when neither at the time the constitutional provision in question was enacted was it in fact the practice of the society as demonstrated by the laws that the society enacted, nor at the present time is it that way. Now, I can understand, and you get into the debate between the evolutionists and the original meaning types when you say, well, what if everybody now thinks it's awful and there are no laws on the books of this sort today, but there were in 1789, so it must be constitutional. It seems to me that's a good debate. But I find it very difficult to say that it's contrary to our most fundamental beliefs when both in 1789 and today all of the states have, permit the practice in question, whatever it may be. Once you don't give me that to hang on to, Senator, I worry that I'm left with nothing to tell me what are our most profound beliefs except my own little voice inside, and I do not want to govern the society on the basis of that.
Well, let's talk about the Ninth Amendment in that context. The decisions, and I don't expect you to comment on how you would rule, but the decisions that have arisen that have been somewhat controversial, where the right of privacy is asserted as being a right that is protected or recognized under the Ninth Amendment. I guess maybe that's the place to start, the Ninth Amendment. You believe that the Ninth Amendment, in fact, implicit in the Ninth Amendment is a recognition of a right called the right of privacy, not to what extent that applies, but that there is such a thing as the right to privacy.
I think that's in effect asking me to rule on cases. I can say the Supreme Court has held that there is such a thing as a right of privacy. They haven't tied it to the Ninth Amendment. As far as I know, there's no Supreme Court holding that rests any right exclusively on the Ninth Amendment. They mentioned the Ninth in a litany of amendments from which various penumbras emanate, and
do you believe that there is such
a
thing as a constitutional right to privacy? Not delineating whether for example, the right to terminate a pregnancy relates to the right to privacy, or the right to engage in homosexual activities in your home is the right to privacy, or the right to use contraceptives in your home is right. But is in a philosophic sense, is there such a thing as a constitutional protected right to privacy?
I don't think I can answer that, Senator, without violating the line I've tried to hold.
Judge, I don't know how you...
I can tell you that that's what certainly a number of Supreme Court opinions now say.
Well...
But there's somebody may come in and say, just as somebody might come in and say Marbury versus Madison was wrong, that it doesn't exist.
Sure, they may come in and say it, but
that it shouldn't exist. I do not want to be put in the position of having I'm sorry, I believe in the right of privacy because I told the committee in connection with its considering my nomination that I believe in it.
Well, the fact you believe in the right to privacy doesn't mean that that a case before you, in fact, rises to the level of being guaranteed that right. I mean, I think you're being a little bit disingenuous with me here. If, in fact, you conclude that there's an existing right to privacy, that in no way predisposes you to have to rule one way or another about whether or not a right is claimed as being qualified under such a right.
No, Senator, I beg to differ. There has been scholarly criticism of the whole notion of right to privacy.
Well, I agree.
And it's not at all inconceivable that criticism will be reflected in a brief before the Supreme Court. And
well, that very well may be, but it doesn't. In other words, if the right to privacy exists, if you believe the right to privacy exists, and I believe you have stated in what was that in the CNN case? Excuse me one moment. I believe, and I can't pin down where you said it. It was in an article.
I don't think you'll find
in the Panhandle article. Did you say that that the right to privacy is one of the deepest and most profoundly held beliefs in our society?
I don't recall having said that, Senator.
Oh, I see. Let me. I'm sorry, I misspoke. What was being referred to was your answer to me earlier, saying that in order to meet your test, it has to be one of the deepest and most profoundly held views in society. And you always, do you have any doubt the right to privacy is one of those deeply and profoundly held view of American society? Forget the Constitution. Let's just talk politics, you and me.
It's very hard to answer. You began this line of questioning by answering me, never mind what the right of privacy consists of. I can't answer that question without knowing what you mean by the right of privacy.
Sure, you can acknowledge whether or not you believe there is, in fact, let's start over again. Clean the slate. Do you believe that Americans as a whole believe that there is a right to privacy that they have, inherent, that they think they have a right to privacy? Do you think that's a deeply and profoundly held belief by American society? Whether it's found in the Constitution or found in natural law or found in their Bible or found in the Talmud, as a society. I mean, do you have any doubt that Americans believe?
I'll give you that, Senator. I think
good man, I tell you, we're getting there. All right. Now, having said that, do you believe that is there any doubt in your mind that the Ninth Amendment, in conjunction with other amendments as it relates to particular assertions of particular rights of privacy, if I can find the Ninth Amendment here so I don't misquote it. Do you have the Ninth Amendment sitting there? Dig it out for me, will you? Roman numerals confuse me, Judge.
Let's see if yours is the same as mine. I have one here, too.
All right. I almost read the 11th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Is there any doubt in your mind that the people, at the time and now, believe they have retained the right to privacy, whatever that means?
No, I think there's no doubt in my mind of that.
Okay. Secondly, if, in fact, that Well, I don't have to go any further, actually. Because in fact, it seems to me if there, in some form or another, there is a constitutional protected right of privacy. What that means remains to be seen, whether it means the right to engage in homosexual activity in one's bedroom, or anything else remains. I'm not going to ask you to comment on that, but let me, and I guess my time, I know my time is up, but let me pursue this one step further if I may. When I look at your musings on the, and I don't mean that in a derogatory way, because I love to read what you've written. I love the way you go about it. I mean, I wish I had you in class. I'm probably too old to have had you in class, but you're the kind of guy that I would have liked to have been in class. I could have gotten by with you because we could talk about philosophy. As long as you didn't ask me what the case stood for, I'd be all right. But when I tie your musings on original meaning and original intent, and where I must admit I put you more in the school of the original intent fellas than I do in the living Constitution area, I begin to be concerned about, and then when I take your second stated principle in the Panhandle article, which is basically that if it is a long-held societal view that has been, in effect, recognized through constitutional interpretation, case law, Supreme Court cases, then you would be very reluctant to overturn it. If I read that correctly, am I putting words in your mouth?
No, yes, I think that's a fair statement.
Now, the irony of all ironies is that the people who are concerned about you, some who are concerned about you, women's groups who are concerned, not all, pro-choice women's groups who are concerned about you, they are worried you'll use that rationale to overturn Roe v. Wade. That is that, we won't go through it all. Ironically, it seems to me you could read your view as saying, if that hangs in the law another 10 or 15 years, it'd be awful hard. You would, by your own test, have trouble overruling Roe v. Wade. So I guess what I'm asking, without asking about Roe v. Wade, is there a time frame? If it's on the law, on the books, if you will, if it's settled constitutional law for an extended period of time, and the argument to overturn that settled constitutional principle does not, in fact, meet the test of, on its face, being consistent with what the correct constitutional principle is, do you have to stick with what the settled law is? I know that sounds good, but you're making it understandably hard for me because we can't talk about specific cases.
I agree with the statement that long-standing cases are more difficult to overrule than recent cases.
What do you have to find as a matter of constitutional principle to overrule long-standing cases? And I'm not talking about any one case now. Constitutional principles enshrined, it's been there, reaffirmed by cases for 20, 25 years. What do you have to find as a logic to overturn it?
Well, in every case, Senator, you have to find that it's simply wrong, that it's not a correct interpretation of the Constitution.
Okay, that's what we're getting at.
You begin with that.
But how do you...
But as I've said, some cases that are so old, even if you waved in my face a document proving that they were wrong when decided in 1803, I think you'd have to say, sorry, too late.
1969.
Well, that's not 1803.
I really am trying to get a sense of
time
the
is
time
certainly
frame.
one of those.
What, when is the wine aged?
It's not just I don't want to mislead you into thinking it's just a function of time.
No, I don't read it as just a function. As I understand it, if in fact enough time has passed, and notwithstanding the fact you could argue that it was wrongly decided at the time because it was a overgenerous interpretation of a right recognized but expanded. That if it becomes settled practice, and the argument to overturn it is not that it was an incorrect decision 25 years ago, but that, because it was too expansive, but is the argument required to overturn it that clearly, on its face, they disregarded what was the clear intention of the Constitution. Case in point, Plessy versus Ferguson. That was on the book long.
Can I interrupt the senator from Delaware? He asked the question, when is the wine aged?
Well, I understand.
I would say the wine's time has come.
I understand that, but I appreciate his biting humor. But I thought this was a serious line of questioning. I'll cease and let my.
Well, it's not a question of cutting
That's
you
all right.
off. It's a question that the senator from Illinois has been waiting and.
Senator from Illinois just asked questions. If he can ask them again, I have no further questions. Thank you very much.
I thank you, Mr. Chairman, if I'm being recognized. You may, after this most recent dialogue, you may wish to decline to answer this next question on your constitutional right of privacy here, Judge. But following a question that Senator Biden and Senator Metzenbaum, may I ask why you resigned from the Cosmos Club?
The basic reason I resigned, Senator, I think I described earlier how I had first become a member. I used the club a lot. I lived there for 6 months. I used it a lot when I was in Chicago, because when I came up to Washington to testify or to do any other business, which I often did since ad law was my field, I would stay there. I came to use it very, very infrequently when I was a member of the court that I now sit on, which is at the other side of town. So I found I was having lunch there maybe twice a year, and I quickly calculated that it was costing me something like $250 a lunch, which didn't seem to me to be worth the trouble.
It's a pretty expensive lunch.
It is an expensive lunch.
But did you, in part, leave the club because you felt uncomfortable with the regulations of the club?
I would hesitate to say that, Senator. I don't know whether that alone would have done it. I told you that I was uncomfortable at doing something which, although I thought it was perfectly okay, was offensive to friends whose feelings I'm concerned about. But I can't say that alone was the reason.
One other question, and I will be very brief. You made a speech on legislative intent, which you say, among other things, if I were writing on a blank slate, I suppose I would call into question the fundamental premise upon which all use of legislative history is based. And then a little later on in the same speech, you say, as an intermediate federal judge, I can hardly ignore legislative history when I know it will be used by the Supreme Court. Now you will become part of the Supreme Court. Do you still believe if you were writing on a blank slate, you would call into question legislative history completely?
Sneaked in.
Yes, if I could create the world anew, I suppose I still would, but I will no more be able to create the world anew when I'm sitting on the Supreme Court than I could when I was sitting on the Court of Appeals, if I ever get to sit up there. And if the burden of your question is whether I would utterly ignore legislative history on the Supreme Court, the answer is no, I wouldn't.
I have no further questions, Chairman.
Senator Heflin, do you have a?
I only have one or two questions. Judge Scalia, I noticed you smoke a pipe. It may well be that someday you may have to rule on the right of privacy as to whether or not an individual can smoke a pipe in his study or in his bedroom. So I hope that you take care of we smokers one of these days. No, I have no further questions.
I have just one or two questions, Judge. You have already testified concerning your approach to legislative history. What, in your judgment, as just as a general matter, what weight ought to be given to a committee report in identifying the intent of Congress in enacting a legislation in which the report accompanies? I think Senator Grassley asked you about a rather unusual situation, and might leave that aside, but just look at it as a general matter.
Senator, as a general matter, I am not as enamored of committee reports as authoritative expositors as some judges are. I may say, by the way, that my view on that matter is not idiosyncratic. There are, my impression is that a number of judges have come to feel that the process has gotten out of whack, that to some extent, because the courts have used committee reports to such a degree, the committee reports are no longer as accurate a device as they used to be. It's sort of the phenomenon of when the cameras go. It's sort of the phenomenon of you're never being able to look at yourself in the mirror and see what you really look like, because you know you're looking at yourself. And it's the same thing with committee reports. Once it was clear that the courts were going to use them all the time, they suddenly became a device not to inform the rest of the body as to what the intent of the bill was, but rather they became avowedly a device to make some legislative history and tell the courts how to hold this way or that way. Once that happens, they become less reliable as a real indication of what the whole body thought it was voting on. That's why I'm sorry if it doesn't please some of the senators, but I just have to say that I'm more suspicious of them than some judges may be.
I raise the matter not merely because of how it reflects on your views as a judge, but it also, I think, could be helpful to us in our committee practices. It's a matter of more than ordinary interest. A case decided by the Supreme Court this term, the Jingles case, Thornburg versus Jingles, turned in part on whether the report of this committee or some remarks on the floor better express the intent of Congress in the Voting Rights Amendments of 1982. And several members of the committee filed a brief, an amicus brief in the issue. Ultimately, the court agreed with us, stating that we have repeatedly recognized that the authoritative source for legislative intent lies in the committee reports of the bill. Now, I gather that you would feel there might be some circumstances in which that much recognition shouldn't be controlling.
I doubt very much, Senator, whether I would not use committee reports at all when I'm on the Supreme Court. But I do think that the view I'm expressing of greater skepticism than has been brought to bear upon them in the past is, unless I mistake my guess, the wave of the future. I think the courts sometimes are beginning to feel that they are being
well, I hope the committee will listen to what you're saying, because I take that as a constructive criticism, and that we could do better on committee reports and be more helpful.
It isn't the quality of the report or the work that's gone into them, both of which are fine. The essential ingredient, however, is for the court to know that when the Senate voted on the bill, that's what the full Senate meant. And if there's some way that the actual attention of the whole body to that particular item, which very often is such a subsidiary item that one really has to wonder whether the notion that the full Senate had in mind this one statement in a multi-page report, whether that isn't utterly fictional. And if it is fictional, then it doesn't really represent the intent of the Senate when they voted.
I have to agree with you. It's a fairly rare event where the committee itself has any argument over the language of the report. And occasionally it happens where a line is written in or a line is stricken out, but that's, I think, the exception rather than the rule. Now, the subject of judicial activism is one that's important to the chairman. You published an article last year in which you noted the tendency to regard the courts as an alternate legislature whose charge differs from that of the ordinary legislature in the respect that while the latter may enact into law good ideas, the former may enact into law only unquestionably good ideas, which, since they are so unquestionably good, must be part of the Constitution. And you went on to say that every era raises its own particular threat to constitutional democracy, and the attitude of mind thus caricatured represents the distinctive threat of our time. I don't think anybody would disagree that unbridled judicial activism is a bad thing. Certainly Thomas Jefferson believed that. Did you mean to say that it is the distinctive threat of our times?
So I guess we have like 45 more seconds to chat. Yeah, this happened occasionally back then. It's just the audio would just cut out. I don't know if it happened at that time. What's really weird is you lose the actual chunk of questioning from Joe Biden's like first round there. By the way, we're not going to go all the way to the end of the session. He had 2 days of hearings, and day 2 was just witness testimony, which I haven't really gone back on. I don't plan on doing Clarence Thomas's witnesses except for the Anita Hill of it all. I mean, how could you ignore it? The others, we're going to be doing Ruth Bader Ginsburg later this week. You know, we want to keep it as balanced as we can. There's no reason to stay on one side of the aisle here because we get, you know, input from senators on both sides. It should be interesting.
Resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put...
You're right, that may have been too broad a statement. In the context in which I was speaking, it's the distinctive threat with relationship to the judicial process of our times. I think if there is one failing, and perhaps in our entire governmental process bearing upon the relationship among the three branches.
And I would agree with the thrust of your remarks earlier today, in which you said that if legislatures were more precise, there wouldn't need to be so much judicial activism. In fact, we invited the one-man, one-vote cases, for example, came about as a result not of legislative imprecision, but rather legislative stalemate on the subject. And it represented a clear example of legislative failure which invited judicial activism, really demanded judicial activism. And in a case in which it apparently was a necessary resort under the Constitution to deal with a problem of major proportions, the malapportionment of congressional districts. Well, I'm glad you have put that characterization into context.
I'm sorry that article's gotten the most attention. It's doubtless of all my articles, it's the one I'm least proud of. I'm not ashamed of it, but it was a couple of page thing in a rather popular as opposed to scholarly publication. Probably not even very popular, but at least not scholarly.
Well, I have just one more question, and that is on the question of original intent. Very popular subject for articles, lectures, speeches. What is your approach to this rather arcane subject?
Well, it's where I start from, Senator. I think the first step is to, and I use the term original meaning rather than original intent, which is maybe something of a quibble, but
Any more votes?
I think that one is bound by the meaning of the Constitution to the society to which it was promulgated, and if somebody should discover that the secret intent of the framers was quite different from what the words seemed to connote, it wouldn't make any difference. In any case, I start from the original meaning, and I think there's room for dispute as to what extent some of those elements of meaning are evolvable, such as the cruel and unusual punishment clause. The starting point, in any case, is the text of the document and what it meant to the society that adopted it. I think it's part of my whole philosophy, which is essentially a democratic philosophy, that even the Constitution is, at bottom, a democratic document. It was adopted by the people's acceptance of it, by their voting for it, and its legitimacy depends upon democratic adoption, either at the time it was enacted. Now, some of its provisions may have envisioned varying application with varying circumstances. That's a subject of some dispute and a point on which I'm quite wishy-washy. But I'm clear on the fact that the original meaning is the starting point and the beginning of wisdom.
Well, my time's up, but the chairman indulged me just to finish that question. What happens if the starting point is zero? For instance, the whole range of public school issues are beyond any scope of the founders' original intent because there wasn't a public school system. And so many of the public school questions that have come before the court couldn't have been precisely forecast by the founders, because you're talking about a whole institution that has been invented since their deaths.
On those types of issues, Senator, that where the law has to be applied to circumstances that just didn't exist at the time, you obviously have to decide as a judge what resolution would most comport with the application of that clause to the circumstances that did exist at the time. You try to make it fit.
Thank you very much, Judge Scalia. Thank you, Mr. Chairman.
Distinguished Senator Milner.
I have no further questions. I would appreciate if we keep the record open, and if the judge would not mind if any of my colleagues have any questions they want to submit in writing, that we include that in the record.
Thank you, Senator. Without objection, we'll do that. See, today is how long do you want to keep it open, Senator? Thursday?
If we could keep it open, but today is Tuesday. Yeah, how about keeping it open till Friday?
Friday?
Friday.
All right, your request, we'll do that. We'll keep the record open for any questions that any member of the committee wishes to propound to Judge Scalia until Friday.
Strom Thurmond speaking right now.
And Friday, say at 4 o'clock.
He was a character, straight out of Central Casting.
Fair enough.
And any member that desires
Same exact
make question about 4 o'clock Friday.
Probably the same doctor.
It'd be agreeable.
Same hair plug procedure.
Judge Scalia, I want to commend you for the way you've handled yourself in this hearing. I think you're one of the best qualified men that's come before us to be a judge on Sacred Court or Supreme Court. Your successful law practice, professor of law in 4 different law schools, at least in 3, and then I believe you're a visiting professor at Stanford. And I've been impressed that you possess the qualities we need in a judge. an excellent judicial temperament, and the other things I mentioned this morning. I think you will be able to assist the other judges on the court, too, in arriving at a consensus. I have a feeling that you're not only a good musician, but you're a persuasive talker. And with your great legal knowledge, I think you'll be able to help with a consensus. You have a reputation for being a hard worker, a man of great analytical skills, sound judgment, congenial personality, and all of these qualities I think will be of great benefit to you on the highest court in our land. The American Bar Association has found you well qualified. It's the highest rating they can give you. They'll be testifying tomorrow as the first witness tomorrow. But I just want to say to you that we are fortunate, I think, to have a man like you to be appointed to the Supreme Court, and I commend President Reagan for appointing you. And I wish you well on the bench, and I'm sure you'll have a successful tenure. And I don't think it'll be necessary now for you to come back anymore. If so, we will let you know. You're welcome to come back tomorrow. Some other witnesses, some for you and some against you if you want to be here, but it won't be necessary.
Thank you, Mr. Chairman. May I thank the committee for its courtesy, and I have genuinely enjoyed being here.
Staying Senator from Illinois, do you have any comments?
nothing
on me
further,
this
no.
time? Staying Senator from Maryland, do you have any comments?
Mr. Chairman, I join with you in congratulating Judge Scalia on a very fine performance
Slam
for
dunk
this
for
committee.
Scalia, huh?
We've seen a good many judicial nominees who have come here, and I don't think any of them have surpassed Judge Scalia in the manner in which he has addressed the questions and the kind of thoughtful responses that he's given to the committee. And as I suggested a minute ago, some of his comments may be helpful to us in the conduct of our own business. So we appreciate your being here.
Senator.
We will begin at 10 o'clock tomorrow. And after we get through with the American Bar Association, we're going to allow 3 minutes to the other witnesses. And we want to finish this hearing tomorrow.
All right.
We now stand in recess until 10 o'clock tomorrow.
Okay, so not bad. Interesting. I found his answer, the line of questioning regarding judicial impeachment was interesting. The question had, isn't this cumbersome? Do you think we should have to take this up in the Senate? And Scalia's answer was essentially, I think the founders knew it was cumbersome, and they want judges to feel like, if someone's going to impeach you, it's going to be a big deal. But, judges should feel like they have the freedom to make decisions without having to worry about being impeached, is part of what that answer was about. Shortly after that, Joe Biden started questioning Scalia on the right of privacy in the context of, I guess, homosexual behavior was primarily what he was thinking about. There's a few cases that have to do that inform, that kind of line, and there's the amendments as well. The Fifth Amendment and the 14th Amendment are really what people refer to when they refer to the right to privacy. Joe Biden kept going to the 9th Amendment, which is unenumerated rights, which are rights that the Constitution, doesn't talk about. They go back to the states or the people. I just want to make sure I got that right. I'm, 99% sure. Safeguard ensuring the enumeration of certain rights of the Constitution doesn't mean the fundamental rights retained by the people are denied or disparaged. Okay. So, other than that, the pipe smoking moment was interesting. I mean, he was smoking a pipe throughout the entire hearing, more or less, not the whole time, tastefully, let's say. But then Senator Heflin, Democrat from Alabama, asked him, or more or less kind of directed him, hey, you don't screw with us pipe smokers and our rights to smoke, in our bedrooms, essentially is what he referred to, I think. But he probably meant, don't mess with our smoking in a bigger sense. And of course, we all know that that was eventually changed. I think it was legislated. I'll have to look that up exactly. Under a health, safety, welfare standard, I think, for public greater good. Is it or legislation? I'm curious. mostly through legislation, not by court rulings. So it was mostly, let's say, Congress enacted, Pro-Child Act, which no smoking facilities like schools and daycares. Okay, and then 2009, Family Smoking Prevention and Tobacco Control Act. I think various states began smoking bans. I know in the 70s and 80s is when they began, and then other states followed. Maybe New York didn't really follow suit until 2000. I remember that because there were places like little pockets in upstate New York that were holdouts, and it was funny. It was good. But okay, so that is Scalia Thomas's. Antonin Scalia's entire hearing that involves his line of questioning, his introduction, his questioning. We went through the entire day one. Day two is witness testimony. We're not going to be doing too much witness testimony. I really want to get to what's going through these justices, these associate justices' minds, including Ruth Bader Ginsburg. We'll be doing that later this week. Later today, Anita Hill, check it out. Mrs. Dave the lawyer will be here as well. Okay? Is there anything going on in the chat? You haven't been tagging me, so I don't know. Unless it's highlighter orange, which is what I say. Oh yeah, give my wife a membership. So I obviously would absolutely give my wife a membership, Alex, but she's trying to do it like right now, right this second. And when you gift them, it's totally random, and I think I went through all 10 of my gifted ones. But yes, Jacqueline, you can use my credit card if you'd like. If you're still watching. Oh, you can't do it on your phone. Interesting. It's literally not allowing you to. Interesting. Oh. It's okay. It's just the dank emojis you're missing out on for now. So stay tuned. I'll say, let's say 12:30. I think we're probably going to be trying to do, maybe if Jacqueline's ready to go in 10 minutes. We'll see. The Anita Hill of it all. As I say, knowledge is power. Subscribe for more. But be well, and I'll see you very soon. In 30 minutes, maybe sooner.